Thanks for staying with us here on the Key Points. Now, for close to 4 months, the country had been debating the treatment of some 499 students who had qualified to enter the Ghana School of Law to pursue the professional certificate program. Now, some 132 of them or so are pursuing that in court. Meanwhile, the AG has since recommended the admission of the 499 within certain scenarios. However, the overall demand is a permanent solution with a view of expanding legal education in Ghana. Hence the notification from Messrs. Dafamikbo and Sosu that they will pursue a private member's bill for reforms in legal education. We were just warming up to that when the AG's Legal Profession Bill 2021 came to the fore. Now, this is supposed to look at the way the profession is practiced and provide that guidance. But now there's some criticism that the AG's document is steeped in conservatism, in traditionalism. It's not in the light of reforms that many seek. And that's our next topic. And let's welcome back our guests. And so let me start with you, Honorable Bemka. So many of us were looking forward to seeing what the private members bill would pose, and in a sense we were blindsided. Of course, those of us not walking the corridors of power were blindsided by the AG's bill. Probably you knew, maybe?
Well, first let me say that the private members bill was specific. It was not far-reaching, and I mean clearly you will know the intent by my good friend and former classmate, Roxin Dafiameko, and his colleague. It was very clear that they had a certain intent. They sought to say that there was a mischief with the structural arrangement of the General Legal Council. And because of that mischief, they wanted to create a situation where we will have a law that will fill in a certain lacuna they find as a result of practice over time. And what they actually found was that the Chief Justice, His Lordship, and the two justices of the Supreme Court, who are members of the General Legal Council, and the fact that the Chief Justice himself presides over the General Legal Council, they found that to be problematic, and that we could resolve that issue by amending the Legal Professions Act and taking out the Chief Justice and the two justices of the Supreme Court. Then we can have retired justices of the Supreme Court who will come and preside. And, you know, one of the reasons I saw wisdom in what they were seeking to say, and I have said it and articulated it time and again at other fora, has been the fact that, one, why will the Chief Justice, who is the head of the judiciary, take an administrative decision which is subject to review by a high court judge? That was one of the problems I had. And I said that I will not even be comfortable, because in the past, on a number of occasions, decisions have been taken by the General Legal Council, presided over by the Chief Justice, and those decisions have been subject of judicial review by a high court, which overturned it. Imagine that as Chief Justice, he supervises all the activities of the justices and ensures that there's a good administration of justice in the system. And then somebody down the ladder is saying that the conduct of the Chief Justice, who is the boss, is unlawful. It's just like saying that a deputy minister, declaring the conduct of the president as unlawful. It's something of the sort. And I find that to be very weird, and it's spanned over a long period of time. So that was the reason why these lawyers came up with the bill, the private members bill, to actually amend this, to take out these senior justices of the superior courts of judicature and to bring in retired justices. So there was some level of wisdom in that. But now we've been given a new bill by the Attorney General, which is far-reaching. That is what I would describe it as, far-reaching proposals if considered to become law and all that.
But
quite a number of those.
I've read it, Honorable Kwenka. It doesn't really touch deeply on reforming legal education in the manner
I'm just about coming to that.
Many had seen.
I'm about coming to that. Because you see, as I have said time and again, and I know my colleagues agree with that as well, is that, you know, you make a law when you realize that over time, practice has shown that there's a certain lacuna which has been created. So you make the law to fill in that lacuna. or there's a certain emerging trend which has not been anticipated at the time you made the law that you are having. And so you're coming out with a new bill which will address the current emerging issues that are prevalent. And so the Attorney General came up with this. If you look at it, certain portions of it are things that I would have to say that, yes, the Attorney General has done well, but there are also certain portions that require some criticism. But remember that a bill is not a law. And I know that when it gets to Parliament, the MPs being who they are and knowing what the system is all about will actually, certain portions of this bill will be cannibalized. I'm not afraid of saying that. They may not go through because of our current situation. You know, for example, I'll pick a few.
Let's not go into the depth. Let me just take the preliminary comments, then we can dig a bit deeper.
Very
so,
well.
Justice, I've listened to the Honorable Attorney General at his 2 vettings, first as Deputy Attorney General and then when he was elevated. And when I read his bill, I didn't get a sense that there's much difference, because I know that he's slightly steeped in the traditional ways, similar to, if you want to follow the comments of somebody like the Justice Sophia Kufu. So I wouldn't say I was too surprised that certain things were kept in limits. But for you, were you surprised? Were you know, was it the usual, like the way you felt, or for you, you had some views? You have some views about the bill.
Jiva, I was completely taken aback reading the bill because I expected a lot, particularly because of the challenges we've been having for the past 5 years. So I was hoping, when I got wind of the new bill, I was so excited with the hope that it would address a lot of our teething problems as we confront them now. And so with that level of excitement, I quickly rushed into reading this bill. And to be fair, I wasn't happy. I saw this to be almost a rehash of the existing law, and the resurrection of dead matters that were problematic in the previous laws, and then, bringing back the ghosts to life in a new act. Jifa, I'm not comfortable with this bill at all.
So you are disappointed?
I am beyond disappointment. I do see, of course, few good things in there, but those few good ones compared to the problems that we have. And I say this first because I'm a teacher. I train students within my limited capacity to become good lawyers, and then I find them in the street still struggling, and particularly knowing the depth of, number of lawyers that we need in this country, to the extent that even the AG doesn't have lawyers. Some regions cannot boast of even a single lawyer. And you train quality materials, and then they struggle to even, to add the little touch of professional experience that they would have needed to support and build a solid country. And then you are confronted with a bill that literally stifle the progress of the legal education, and I honestly do not see.
So you would prefer we maintain the current law,
the current system. In fact, if we go into the details, I'll point out that what we have presently and the kind of introduction that we are bringing in are not necessarily different. So, that's why I said that there are areas of the existing law and existing practices, actually. So, for instance, let me just point out this. We admit that the General Legal Council doesn't have that far-reaching authority over the faculties. But Jifa, it would be a lie for you to think that the faculties do not take
what they say
seriously. As a matter of fact, in practice, when the General Legal Council comes there, even without this legal framework existing, the observations
are very important. Yeah. I think I saw the report that was issued some 3 years ago.
We all know the examples of Montclair universities and other private universities, what they've gone through without the General Legal Council even having to belch. And they didn't even have legal authority to do that. Yet, this is the kind of authority that you've had. And this new bill is simply just giving them that foundation.
Okay,
which
so
they have in practice.
Okay.
So that's why I'm saying that. This is just one example.
Yeah, that's just one. We'll come to the other examples. Abraham, good attempts or more work to be done on it?
I am confused as to what the purpose of this bill is. Because I know that there's a raging issue. That is lack of access to the professional law course. And I thought that, when I heard it, that there was a bill, I thought that it was addressing that. But I read the whole bill, and there was nothing addressing the issue of access to professional legal education.
Maybe it's deliberate. After all, if you have 2 MPs who are sponsoring that aspect, why make it look like you're selfish? Let them handle that, and then I'll handle the other bits.
But there's nothing wrong in incorporating good views from other persons. Okay. I mean, we were just talking about engagement, and it's good. Former Attorney General mentioned that indeed. Joe, I don't know whether you still like that name, former Attorney General.
Deputy Attorney, former Deputy Attorney General.
He's still Attorney General. Even a lawyer in Attorney General's office is Attorney General, and he knows that. So this one, in practice. So long as you're a lawyer in the Attorney General's office, you are the Attorney General. And so if you go to court, nobody gets his case called without your permission. And he knows this. This is the practice. And so even if you are 1 day old at the bar and you work in his office, you are God.
You're there at the instance of that.
So now he's taking you to. So yes, Abraham.
So he's the former Attorney General.
So the bill has not provided any solution to the admission brouhaha we have at the law school. I see the bill trying to elevate views of some members of the General Legal Council to become law. I'll give you an example. He touched on the Sosuk matter, where Sosu was rusticated or was it suspended, and then a high court overturned it. And clearly, this is on record. Samoku Jeto, who is a member of the National Committee, was furious that how can Supreme Court judges sit as an administrative body, give a decision, and then a high court judge will overturn it. Now, if you look inside this bill, it seeks to elevate that is view to be law. Is there? How did they do it? They are now saying that you can only appeal to the court, Supreme Court, not even the Court of Appeal. So they are now equating the quasi-judicial body, which is the General Legal Council Disciplinary Committee, to a high court. So now, when you are going to appeal,
you have to go above them
to the Supreme Court. And hear what they are saying. With leave. So, with leave from the General Legal Council or the Supreme Court. So they are tightening it and tightening and tightening. So, I see the bill trying to address people's personal views on how general legal education should be, the profession should look like, and not a bill that is addressing the concerns of practitioners, students of law, and the Ghanaian people.
I thought that's a premature critique.
I thought that
because the bill will go through public engagement and discussion.
I thought that with such a bill coming from Attorney General, he would have done some consultation. How about deans of faculties of law? Because this bill is heavy on the faculties. Yeah. It's heavy on the faculties. How did he engage? Has he engaged them? It's the same thing we are coming to with the budget thing. You don't get there and then you are shut down and you say, I want to engage. So it's a problem.
So there are some issues for you. All right. So Honorable Penka, you said there's some good things and there's some things that may eventually not make it through. What for you are the good, and then those that you feel may not see the light of day probably?
Well, first of all, let me look at the negative. For example, you see, you have provisions reintroducing, for example, the entrance exam with interviews. And this has been one of the most contentious issues in the past. Especially, you see, I know they are addressing these things based on the previous experience, because it is anticipated that a lot of people normally, people think that a lot of people fail the exam year in, year out, and then we churn out failure and mass and etc. So you will have a situation where they may soften the marking scheme, but introduce interview as a way of, but you see, at the interviews, people noticed a lot of errors in those days. You could have somebody who scored very high marks in the exam, goes for the interview and he fails. You don't understand. Somebody will score very low marks, he goes for the interview, he passes. Because at that level, there are some panel who are there, and as to maybe if somebody comes happy that day and you appear before him, you may be lucky. If he comes unhappy and you appear before him with all your intellect and etc. So that has been reintroduced, and I think that over time I will not support that bit, because I think that we just have to find a way of opening it up so that the faculties can be strengthened to run the professional courses, and then there's a regulatory body that runs the exam. That's my personal view. So I think that bit about the exam and interview is negative. You also find that we are introducing something that happens in other countries, a certain category of lawyers, senior advocates. And they are going to, when I saw that, they are going to even be dressed differently. You know, those who are 25 years and above at the bar, they will now be called senior advocates. You know, as we speak now, we have, by the Ghana Bar Association standard, we have junior counsel, we have counsel, and we have senior counsel. A senior counsel starts from 10 years and then upwards. So as we sit here, we're all senior counsel. And so now they're coming up with a new one, which is that you will now be called senior advocate if you're 25 years.
They'll write the SAG after your name.
When you appear, to practice, priority will be given to you.
I grew up in Nigeria. It's very popular.
I hear it's popular in Nigeria.
Yes,
it's popular in Nigeria and all that. And we are trying to replicate same in Ghana. I don't know what the thinking is, but you know, our profession, I must confess, is a very conservative one, and we respect seniority a lot. Maybe that is what has actuated this, to give credence to the fact that seniority ought to be respected in its entirety as far as legal practice is concerned. So when it is brought forth, well, it will give credence to the fact that seniors should be given some level of elevation and respect. I don't have much problem with that. But the far-reaching suggestions that have been made about the faculties, if care is not taken, some of them may close down.
They must meet certain
level standards and criteria. And all that. And you see, again, there are many people out there who are interested in becoming lawyers, and they go to these faculties. The faculties are liberal, and their admission requirements are there. If you have some of the universities will tell you that a good first degree, and they define that to mean first class, second class upper, or second class lower. That's what they define a good first degree to mean. Then you can apply. Some of the schools too, they allow for people to come from the SS, and they are very strict. Some of them consider grade 6 and a grade 7 for admission to the 4-year program and all that. So all those things are going to be looked at, and I don't have much problems if it is meant to ensure that we have quality out there, but it should not be a stumbling block on the way of certain people and create opportunities for only privileged people to have legal education. That I would not support. Again, if you look at I started something, and my brother Amaliba eloquently articulated that aspect as well, which was the issue of the structure of the General Legal Council as it stands. And I have said it time and again that for me, I thought that it's been long overdue that I sit as a Chief Justice and I take a decision and the High Court judge tells me that I'm wrong. I mean, that was one of the most ridiculous arrangements we could have in that legal arrangement. So to say that you now want to elevate it to the status of a High Court or a Court of Appeal, and that a decision of the Supreme Court, of the General Legal Council is appealable only to the Supreme Court, is an attempt to address that concern, which all of us have actually articulated over time. But you see, the reality too on the ground, and we have to admit, I know my brother is aware, some of the faculties lack a lot of basic things. You know, when we did that, there was
a report
research, that
put
report.
Together
in fact, I was
2 years
part
ago.
of those who went out to the various institutions. We're in a number of committees, and my committee was headed by Supreme Court Judge Justice Jones Doche. He led our group, and I think he led us very well and did a very good job and did a very good assessment. Some of the faculties were really lagging behind. Some didn't have qualified lecturers. We didn't have enough qualified lecturers in the system.
So the quality of the libraries were poor.
Yeah, they were very
and
poor.
And then the access to information in terms of
all
legal
these
documents
things
and the like.
are reasons why they are now introducing this into the bill to ensure that we have far-reaching reforms that will ensure that the faculties meet certain basic criteria before. So, you see, faculties will not be established as just business entities or business-making ventures, but they should be established to ensure that people get quality training and meet the basic required standards that will lead them to become professional lawyers to do their practice well. Because you see, sometimes, I know my brother, he's a lecturer, and I know that some of the faculties, you have somebody coming out with second class upper or first class or lower, and then they go to write the exam, professional exam, and the performance does not commensurate with what they got at the faculty. So you don't know how the person was able to pass there. And then, I mean, how? Out of 100 marks, I saw that the last exam they wrote, people got 6%. 6. How? You have LLB, and then you go and write entrance exam and get 6.
On the same subject you've treated.
The subjects that you have treated. It will tell you that either you were not properly tutored or you were just asked to pass through. And then because you have the ability to pay.
Maybe the person just didn't study.
Well, but that would be quite simplistic though.
Yeah,
there would be a lot of challenges that would account for that.
But to be honest, I don't want to give any excuse why a person with LLB will go and write entrance exam and get 6%.
Okay. So you've mentioned the issue of the entrance exam, the SAG, the faculty requirements, the structure of the GLC. Anything else?
Well, basically,
those are yours. So what are the good things?
These are my thoughts. I mean, of course, what I've said here, some are good.
Okay, so the SAG for you, not a big deal. Improving the state of the faculties is okay, but you are not sure about the GLC bit.
The GLC bit, I think that if we maintain the GLC as it is now, then I'll support the proposal that a decision by them is appealable to the Supreme Court.
Otherwise, you take them off as being proposed by Dafia Makbo.
Then this particular thing, the appeal to the Supreme Court may not be necessary anymore.
Yes.
But remember that, I mean, when you take a decision as an administrative body, it's always subject to judicial review. And that is what the Constitution is.
That's okay, so let me come to you, Justice. So for you,
anyway,
what are the things you are... so what are the things that you are not happy about?
Okay, so before I go into that, I just want to address an issue. You see, because it's an administrative decision, see, the problem is that you may not even exercise a right of appeal. You may exercise a different constitutional right, either by way of certiorari or other things. And that will still go back to the same court, high court. And so what you were seeking to avoid, you still have it. What that means is that, and this is even the weird part, even though now the GLC is being equated to the high court, the appeal doesn't go to the Court of Appeal. It rather goes to the Supreme Court. And that's another weird part of this whole new arrangement being proposed here. I don't know whether you've studied that part. I mean, because I would have thought that naturally, the natural sequence would be that if the High Court takes a decision that you are not favorable, that you intend doing an appeal, it's a Court of Appeal that you go to.
Yes, let me just tell you the reason again. It is
I understand
the thing that the Court of Appeal justices too cannot be.
They are still lower.
They are lower.
They are still lower.
Exactly. That is the policy right now.
I get it, but my point is that it's a weird arrangement that you jump the Court of Appeal and go straight to the Supreme Court over an appeal. See? And particularly so when you are not sitting as a justice of a court, you are sitting as an administrator, taking an administrative decision, which is subject to a review.
So if you're the Chief Justice sitting in this instance,
and that makes it even weird.
It means so it's two things. It's either you consider yourself in that moment as not per se being the Chief Justice and doing this work as an administrator, which is then subject to review, or we remove that difficult protocol element. such that whoever does it is not a CJ, not
or even a member of the Supreme Court
judge,
because
and then
even that will pose another challenge.
And then the protocol will
you go
match.
to the Supreme Court where we have limited judges, and about
and
three of them, minimum of three of them, were sat on this one,
there.
And then there will be the issue of conflict of interest, because the same Supreme Court is where you're going for a redress, and the potential conflict of interest scenario would arise.
Well, maybe in the panel, and certainly those people who
will not be part of it. That's what I'm saying.
No,
but that's why I raised the issue of the numbers there. We don't have enough numbers in the first place. And so if you are removing 3, how many would you be left with?
Okay.
Of course, I understand that you may have 5 to be properly constituted and take over and take a decision. But why would you put yourself in this whole drama when you can avoid it completely?
Okay, so your points.
So that's on that.
Because then
now,
we'll have to take
moving
Abraham.
on, you're asking about the positives. Indeed,
what are the good for you?
They're good. There are a lot of few of good ones. The first one being, for instance, the extension of the period of pupillage. The pupillage usually, once you step
it's 1 year.
Is 1 year
now?
No,
yeah.
it's been 6 months. It's been 6
okay,
months.
6 months.
All these years.
6 months.
Now the proposal is that
Mm.
it's supposed to be 1 year. For me, that's a very good one,
okay.
and it's something that we should comment. Now, in addition to that, the issue of the renewal of licenses. Now, there are other protocols that have been put in place that
are now extended to those in legal aid.
Thank you. No. You're talking about a license from the AGs. In fact, that now captures the entire government sector now. So that once you're a member of government or you're a member of you work for the state, you are not required to take licenses. In the past, it used to be just the AG's office. Now, almost everyone else is. Now, beyond that, the private sector. People don't practice. Some people do not practice. So because of that, we have as many bad lawyers as few other bad judges. And the reason is because they don't practice. But somehow, occasionally, they probably may go to court or may get an opportunity to become a member of the judiciary. And you have difficult decisions to deal with. Now, what the proposal here in this new bill is that before you can even get your license renewed, you should have undertaken some few courses, at least minimum of 12 hours of continuous legal education. And for me, that is important, at least to refresh your mind so that you'll be abreast with new trends and other things in the legal profession. And I think that should be commended. It's a very good part. And then, of course, there are a lot of big firms, law firms, who do not offer, who do not care about the poor. And we are in a country where we have majority in that poverty line. For me, in my law firm, we offer a lot of pro bono services, except that the way we do it is to ensure that we do it through the legal aid services, so that you don't just walk in. If you walk in and we find your case to be meritorious, we refer you to legal aid, go get an authorization, then we undertake the case for you. Now, what the new bill proposes that now it is going to be mandatory for every law firm, every lawyer, to do a little pro bono services, but through the legal aid scheme, which is very good, so that the mantra that every prospective law student tells interview panel, i.e. that he would want to be the voice of the voiceless and the defender of the indigent and the poor, and that will now become a reality, because there are lots of people who do not have legal services purely on the basis of the economic circumstances. Now, this bill seeks to address that in this nice way. There is also indeed, if I have to go on, I don't know how many minutes I have.
So just 2 minutes but quickly.
Yeah, there is a provision dealing with a little with quack practitioners, fake lawyers, if you want to call them, and people who are not lawyers. And then there are issues, and that is very positive, because in the past you may have to fall on the Criminal Offences Act, which will deal with impersonation and other things. But now we are dealing with this part of it because they are so rampant. In fact, in the past few years, there are a lot of fake lawyers being arrested by the district court. And the district court are where they practice the most, because that's where you will never be known. Because there you don't do much of law.
To the rural
of course, the rural
areas.
areas. Yes. These days, the rural areas are actually in Accra. So they'll just be around the
precincts of the court.
Thank you.
Tell us, what are some of the things you're dissatisfied with?
Jiva, importantly, now there is a new provision introducing a quota system.
For the faculties.
That is huge. That is very huge. I have to be honest that in the existing structure, even though it does not put positively quota on the faculties, but the faculties have had a standard of always admitting between 100 and 150 per session. Now, I say per session because now most of the faculties are now running weekend streams, regular streams, and then evening streams. So a nice way of dodging what is not really a quota, but a standard practice of 100. So instead of having 100 per class, so which would mean that if the person is running, if the institution is running a 4-year course, you should have a maximum of 400 students. But what now is happening is that
you have 3 times that
Three times that number. 3 times that number. Now, the introduction of this quota system, and it's not clearly spelled out as to how it's going to be. It's literally going to mean that, assuming it means exactly what it means, that means that you're going to have a maximum of 400 students in a particular law school, and that is really problematic. And I say this because, as I've said earlier, we have huge requirement for lawyers. We need a lot of lawyers. And you cannot overemphasize that. I mean, presently we have barely one lawyer is to about 10,000 clients. That's the average. One lawyer to about 10,000 clients. And that's actually not average, that's the minimum. It could be worse. And the Attorney General's office is the hardest hit, apart, in addition to the other government offices. And so if you have this huge vacancy and you have private sector and indeed other public sectors producing quality lawyers, I mean, I would expect that you rather focus on regulating them to get the best out of them rather than having a positive
So for you, the quota restricts access. What you would have liked to see would be a path to progress where the faculties run the professional course.
But that's part of the negative, yes, that I was coming to. Now, as we all expected, I mean, I'm sure everybody expected that the faculties were going to be granted
access or opportunity,
licenses to run the professional course. And strangely, it has nowhere in the new bill. There's absolutely nothing, even said, not a scintilla of
there's something. There's something that says that all these mechanisms they are putting in place regarding the faculty is to strengthen them in future to be able to take the professional. There's something like that.
Yeah, but you see, that's the point I'm making.
Doesn't give a timeline.
There's not just a timeline. There's nothing, literally. This person is saying that he's strengthening you. I mean, you don't. I mean, what the extent to which that is going to be done, for how long that is going to be done. These are problems, and you have a problem today, and you are looking into an uncertain future. It could be worse in the future. So we have to address it now, here and now. This is the time that we have the problem. Not future that we do not know whether or not the problem may even exist and how the nature of the problem as at the time that we are confronted with it. So let's address it from today. Let's have the faculties, at least those that have the strength, even if there are 2 faculties, only 2, with the capacity to administer the professional law course. You grant them the licenses from this, and then they can be used as a mentor institutions for other institutions that may want to run the professional course in future. Because I cannot be convinced that there's no law faculty in Ghana today that cannot run a professional course. I can't be convinced.
Okay.
There are a lot of lawyers in almost all the faculties. Now, in fact, virtually all the faculties now have practitioners with various levels of experiences and with academic qualifications in addition. And at the professional law course, what you need is actually the years of experience. That is what you need there. Okay. Now, the faculties have this in addition to the academic qualifications. What more could you have, ask for?
Okay, so your quick view on the SAG proposal.
And as for that one, I do not think it's necessary at all. I don't think it doesn't help anyone in any way. I think if there's anything that we need to do, the idea of the jerseys, it sounded quite innovative. I mean, giving them a jersey, sort of. And I was thinking, really, if that is good enough, if the idea of the jersey is good enough, why don't we rather implement it now? Because now it's so difficult because of the proliferation of the law faculties. Now it's so difficult to identify a senior lawyer and a junior lawyer, particularly because of natural age.
So a person may come. We should identify the senior lawyers. We don't necessarily have to call them SAGs.
No, not at all. So, but there should be a way of identifying a senior lawyer, either by way of how he dresses or maybe by way of a tag or by something else. But because really the natural age is now becoming very deceptive. Yeah. Very, very deceptive. And the idea of a junior lawyer.
There are people who are 50 years and they are 1 year at the bar.
And there's, in fact, Even 70, some are post-retirement.
60 years.
Post-retirement, and now he's now a lawyer.
And then a 20-year-old person at the bar is seated, and
they call the person's case.
Because of his appearance and all that.
Jifa, you may not understand the importance of this because you probably may not be a lawyer, but the importance is that it helps that person, that young lawyer, to learn.
And to aspire.
And possibly.
I see it as an aspirational thing.
It's that motivating that you sit at the bar and you learn. And that's the time of learning. Really, you learn at the court. You learn more in the courtroom than you learn anywhere else in the world. And so if you are losing that because of your natural age, then really, what's the point?
Okay, let me come to Abraham. I've given you quite some time.
Actually, because I have much of the negative listed.
The producer is going to
let me just add one.
Okay, add one.
See, and that's the introduction of which I still exist, the independent examination body.
Okay, yes.
I honestly, strongly feel that we can have that institution, that establishment, that should rather be a supervising authority over examination, in the conduct of examination, if the faculties were given the opportunity to run the professional courses, so that they would rather be the WAEC of the General Legal Council to administer exam and then to do the marking and however they would want to do it. I think that is the best way of going about things today than to have that independent examination body to do the things that they are doing today. I don't, because really today, the present structure is such that I think, honestly, that the lecturer would be a better person to assess his own student, because he knows the weaknesses and the strength of his students. And he knows what he taught and what he didn't teach. Admit that, of course, there's a course outline that we would have to follow. But there are genuine reasons why a lecturer may not be able to complete his course outline. And you would have to give him that benefit of the doubt to examine his students. And he may have his own ideas as to why he thinks the students ought to be examined on this. Yours is to give him the parameters, and he would have to follow.
Okay. Abraham, your thoughts?
I thought that this bill would have been addressing the intake at the law school, but you realize that they are rather engaged in areas that are not profitable to the practicing lawyer. For instance, what some of us have always argued about is, in this hot weather, why should we be carrying wigs and gowns?
You are one of the few lawyers who has expressed views against this. I know many, especially the younger ones, they even want to wear it. So I'm not exactly sure if that's going anytime soon.
But there's a school of thought among the profession that we need to, wear clothing that are friendly to our weather. And in some countries, even where we borrow this from, the UK, they've done away with the wig, So these are matters, if they were minded, they could have looked at. But you see, it is an affront to the rule of law to elevate an administrative body to a position where that administrative body cannot be reviewed. His decision cannot be reviewed by a high court. Okay,
so you're talking about the GLC. I think you made that point earlier. So for you would stick with Dapia Makpo and Sosu's view that the Supreme Court justices be removed from the GLC.
You made a point, and that is where I want to touch on. That, and I think Pinka also touched on it briefly. Once you decide that you are a Supreme Court judge and you come and sit at the district court, you are a magistrate.
And I think that needs to be emphasized.
That's all.
That even if the Chief Justice sits at the district court, he's still he's not the Chief Justice at that moment.
So if you then want to still carry your Supreme Court, your Supreme Court position to the district court, it is a no-no. So they need to understand, either they leave the General Legal Council for judges who are not of their stature, because definitely matters from the General Legal Council will come to them, or they begin to imbibe in their minds that once you decide to go and sit there, you are an administrative body, you are not there as a Supreme Court judge. That, for me...
And then your decisions will be subject to review, whether at the High Court or wherever.
But you see, a man should not be working all his life with an albatross around his neck. That's why litigation must come to an end. Now listen to me. Listen here. The disciplinary committee may postpone indefinitely. That's the decision of the Supreme. May postpone indefinitely or for a specified period the making of the decision or disciplinary committee whether to take the disciplinary measure or not. Now, and I've just said that I cannot appear before you. Then you take a decision. You say, I will not communicate or I'll postpone the decision. And Amalba is working. I sleep and wake up. Oh, General Legal Counsel. Wake up, General Legal Counsel. There must be a decision and communicate it. They are equating, and my colleagues here would agree with me, they are equating the General Legal Counsel, the disciplinary committee, to a high court. But in the high court, there's time limit for passing judgment. In the high court, there's time limit. Within that period, the judge must give judgment. So if you are equating it to that place, why would you then come and be making this type of comment here? That the decision can be suspended. And what is my fate? I sleep, I wake up, I'm frightened. So there must be, this must be shut down. There must be a way to end all litigations. And I think that this is not proper.
I know that you're also against the SAG concept.
The SAG concept is about for those 25 years and above. I'm not close to 25 years. I'm close, but I'm not there yet. So I'm not too worried about it. Look.
Senior counsel. Is it not? He is.
But isn't the perception that if some lawyers are tagged SAG, they may have an advantage over other lawyers?
That is the discriminating part of it.
I know that T.S. Ward-Brew had taken this matter to court before.
Yes,
is it in the 90s? And he won.
Yes. And
against
on a different platform, with you, I espouse this view that it is discriminative. It is a way to stifle the economic rise of some lawyers.
But it's not
because
fair. It could be aspirational.
No. Clients, people who are watching, clients will say, oh, almost way, this one is the best lawyer. Because that's how they
I get that.
Then the rest.
Even licensing has been equated to
that. But it may...
They'll say, look at the dressing.
Yeah, have you dressing?
Okay, but it may also not be as you say it. An SAG may also be so expensive that we will go with an equally good lawyer who is not 25 years and more at the bar.
That is where those of us who are not SAG would have to be polluting their minds. Almost their minds, their fees are high. Their fees are high. But do we need all this? Do we need all this? We don't need it. It's needless. So please.
So maybe the Jesse, at least to identify a senior.
Yeah, I agree. I agree to most of the things they said about now at the court. When you go to sit at the bar, you will not even know who is a senior, who is not a senior, because people who are with gray hair and they are still juniors. So it's important, and sometimes you need to ask, can I take a date? I'm not going to avoid all those things, we need to identify those who are seniors and those who are juniors. That's all. Yeah.
So, okay. Now, what for you? You mentioned something else that you were in. So I know when I spoke with you, you said
yes.
You said so the interview portion had already been struck out by the court. So if you're bringing it back, it's almost as if you're disrespecting what the court had said.
Yeah, so they are now making it part of the law. There was a case by Prof. Ansah. I think that the issue of the exam and the interview were struck down. They went to Professor Ansari. They came with a law to bring back the exam.
No, you see, it was by an ally.
An ally, rather. They brought the exam back, and now they are bringing back the interview. You see, to be honest with you, the tools of a lawyer are his ability to present his case in court.
Not all of us are good speakers or argumentators like you.
I know. But nonetheless, the tools of a farmer are the cutlass and hoe. Every profession has tools. We as lawyers use oratory, and that's our strength. That's what we do. So I think that the interview is a way to gauge how this person can perform if he's eventually called to the bar. So for me, I would, in some way, see that as a good thing. Once it comes and they are able to pass it into law, that for me is a good thing, where the ability to present your case in court will be tested even before you become a full-fledged lawyer. I think that for me is a good thing.
All right, and that's where we have to end it. I want to say thanks to our guest, Abraham Amaliba, Head of Legal Affairs, NDC. Many thanks to Justice Abdullah, lecturer at the UPSA Faculty of Law, and also to Honorable Pemka, who is a former Deputy Attorney General. And my name is Jifa Bampo. Thanks for watching the Key Points. Many thanks to all of you for your messages on Twitter and also via WhatsApp as well. Enjoy the rest of the weekend. Up next, of course, is our sports show, Warm Up Plus. Many thanks to the entire production team.